Can I just say something about Andrea?
Hey everybody, welcome back. I hope you are all getting ready for a fabulous new year, 2026, nearly upon us. Well, guys, it's time to do our deep dive, our LawTube for Lawyers style look at Luigi Mangione's motion to suppress. And I wanted to go into this in a little bit more depth because this is a kind of issue that if you don't know it's there, you're probably not going to know that it's there or understand why it's so significant and why it is that this particular issue is really likely to be kind of dispositive on the motion and what the outcome of it is going to be. And this issue has to do with the distinction between when you apply New York law, when you apply Pennsylvania law for a search that took place in Pennsylvania, but is going to be used in a prosecution for a murder case in New York. Now, I want to start first by just briefly taking a look at the memoranda that the parties filed, because you won't see anywhere in them any kind of reference to a choice of law or a conflict of law type of issue. In fact, what you see when you look at the defense's motion, you see nothing but New York law. And it just describes, here's the Fourth Amendment standard. Burden is on the state to establish an exception to a warrant requirement if a warrantless search is conducted. Just, you can look through and see their version of the legal analysis here is all based entirely on New York law. Now, we didn't get any kind of response from the state in any kind of meaningful way. Here is the state's response to the motion, and they don't say in this, it's fine because Pennsylvania law applies or something like that. They just say, we dispute the facts and we consent to have a hearing. And they did that for both of these issues that were raised in the motion to suppress. So, not real obvious that it's an issue, but then we get into the hearing and we start getting the testimony from all the different Pennsylvania law enforcement officers who testified about, this is Pennsylvania. We did things the way we're allowed to do in Pennsylvania. We applied Pennsylvania law. We don't even know New York law. And so it became quite clear, at least to me, pretty early on, that the state wants us to look at this under Pennsylvania law. Now, Karen Agnifilo, still not sure exactly how to, so I'm just going to do it. I'm just going to pronounce her name the most Italian way possible that I can. Agnifilo. She's not an idiot. Okay. She filed a very extensive brief. It's, 8, 9, maybe 10 pages long. It's all grounded in New York law. And she didn't just forget that all of this happened in Pennsylvania. She didn't just, fail to take account of the fact that this all took place across state lines. So I do think there was a reason why she briefed everything in terms of New York law, and why it looks to me that the state's attempt to try to get the court to look at this through the framework of Pennsylvania law is it's a bit of a Hail Mary, and frankly, one that I think is likely doomed to fail. And so we're going to take a look at that now. We're going to take a look at why exactly that is. That don't think the state is on a good good footing here to argue that we need to apply Pennsylvania law and those standards to what took place in the arrest and search of Luigi Mangione. So the first thing I'm going to share with you is this little bit of briefing that I found. Let me make that bigger so you can see it. This is like canned briefing kind of, which is to say, like, a lot of times when you're an appellate attorney, and sometimes even in a trial level, when there are issues you brief over and over and over again, motions to suppress, things like that. You don't have to research the same law over and over and over again. You find like one good brief where you wrote on this issue pretty extensively, and then you can just kind of go ahead and recycle that and repurpose it and reuse it in different types of contexts. So I found this online, and it's kind of some canned briefing on this particular issue. So it's conflict of law or choice of law. And so this was a situation where there was a search that was performed, and question comes up: do we apply the New York standard for searches and seizures, or do we apply military law? So in this particular case, the appellant is arguing the trial court applied military law. That was not appropriate. We're less interested in the facts of this particular case that's being briefed as much as we are the law that it's relying on. The facts are just telling us this is the same kind of context where you have a search that's conducted and the possibility of different types of law being applied. And so how do we decide which one we're going to use? And that's what's interesting about this particular canned brief, is it gives us a very comprehensive breakdown. A lot of citations. We're going to follow up on some of them so that we can check their work and kind of see for ourselves how this is how this is looking. So the New York conflict of law rules. First, we got to look at, is there actually a conflict between these things? If they're the same standard, then it doesn't matter. It's kind of an abstract point to say, well, it's New York law or it's Pennsylvania law. It doesn't matter if it's the same thing. So it really only comes up in situations where you have different standards. And so in this particular case, he's arguing, well, there's some differences, but ultimately it should be the same. But when the result would be the same, or there is no conflict of law issue, New York courts have consistently held that the law of the forum where the case is tried will apply. So the forum is where the trial is happening, the forum state. That's New York for Luigi. He is being tried in New York for a crime that was allegedly committed in New York. So New York is the forum state. So everything else being equal, we apply New York law. Now you'll see a lot of this is relying on civil citations. There are some criminal ones that we'll get to later on, but that's because it's just much more common to run into these kinds of issues in civil cases than it really is in criminal cases. And that's just because of jurisdictional limits and things like that. It's just not really that common for crimes to kind of cross borders and stuff like that. Definitely not unheard of, but it's just, not a thing that happens like every day. It's a small percentage of the total cases that you deal with. But it happens a fair amount in civil cases because you're dealing with a lot of, business transactions across state lines are pretty common. People drive on vacation and get in car accidents and stuff like that. So it's a lot more common that it comes up in the civil context. And so because of that, the criminal cases have borrowed a lot of the same analysis that the courts developed in the civil context to decide, look, if we've got a guy who lives in New York that drove to Florida and got in a car accident in North Carolina, we have to sue him in New York because that's where he resides. But what law applies? You got to look at these different considerations. So that's what this is telling us. These rules are about what are the considerations that the court is looking at in deciding, are we applying New York law? Are we applying an out-of-state law? So if the court were to find that a conflict of law exists, then New York law's rules have two different methods of analysis: the procedural versus substantive analysis and the paramount interest analysis. So two different tests that they can look at to decide, do we apply New York law to Luigi's search, or do we apply Pennsylvania law? So first, the procedural versus substantive analysis. So under this test, the New York courts have looked to whether the right at issue was procedural or substantive. If it's procedural, the forum's law applies. So classic example of this would be like rules of evidence. If you get arrested in New Jersey and you're going to be tried in New York, there's no argument really that the New Jersey rules of evidence should be applied to the New York courts. They have their own rules of evidence. These are just procedural things that establish kind of the ground rules for how to conduct a trial. And so, states get to have some leeway with how they go about those types of things, as long as they meet the basic constitutional minimum. But the problem is that the procedural versus substantive distinction can be quite unwieldy. This is one that comes up a lot in federal cases. A good example of this is in the case of anti-SLAPP statutes, laws that set up procedures for kind of summary adjudication of lawsuits involving like defamation claims, intentional infliction of emotional distress claims, cases that are alleged to be based on the exercise of protected First Amendment activity. So federal courts don't have their own anti-SLAPP rules, but state courts do. And so the question has come up repeatedly over and over again across the country, are anti-SLAPP rules procedural or are they substantive? And this matters in that context because federal courts apply the substantive law of the state in which they're situated, but they apply the procedural rules of the federal court. So if anti-SLAPP is a procedural requirement, then there is no obligation on the federal courts to use it. If it's substantive, then they do have to apply it. And so this is not universal how this breaks down. There is, to my knowledge, currently one federal district court down in Florida that has decided this is substantive law. And so state anti-SLAPP law will be applied in federal district courts in Florida. I forget if it's Middle District or which one it is, but it's the Gawker decision, which you may have heard about. Most other courts that have looked at this have said that it's procedural, so they don't apply it. So it's not exactly like real cut and dry, black and white, crystal clear when you're going to have a procedural distinction versus a substantive one. And this is particularly the case when you're dealing with things like motions to suppress, because it just depends on how you kind of frame it. You can always frame a motion to suppress as just an evidentiary issue. It's whether evidence is going to come in or not. And so in that sense, you can always say it's procedural. And in that case, you would always apply the law of the forum state under this rule. But the thing is that motions to suppress, when they involve, Fourth Amendment rights, privacy implications, the scope of a person's privacy right, pretty good argument that there's at least a component of that is substantive. And so defining the scope of a person's privacy right, could justify a conclusion that that differences between states and how that's interpreted are differences of substantive law. So it's a little bit unwieldy, you see. But so they've got these two cases here, Benson and Graham. And they describe, some of this criticism that I've just given. The distinction is often unclear. Courts have expressed dissatisfaction, have generally opted for the other test, the interest test. So it's there, but is it like really super helpful? Not entirely clear, but because why not? Let's just go ahead and take a look at their cases that they're relying on for this proposition. So we're going to start with People versus Benson. Some of these cases, the factual exposition is kind of short, and so we'll go ahead and go through it. Other ones, it's many, many, many pages, and so I'll just summarize it when we get to it. But this particular one is a murder case, and the defendant has basically left the jurisdiction. He's gone to Texas, and so this is probably, at least from my perspective, the most common situation where this choice of law situation comes up in criminal cases. You have a crime, the crime is not immediately solved, and the defendant leaves that jurisdiction and goes to another jurisdiction. So he's arrested in Houston. He's interrogated there, and the question is, his statement made to a New York police investigator at the Houston Police Department, is it admissible? So first they're saying, well, it hasn't been properly preserved, but nevertheless, they're going to go ahead and kind of look at it anyway. So he's arguing that the statement was a violation of his Miranda rights because Texas law requires that he be apprised of his right to terminate the interview at any time. And also another Texas law requires that the statement be electronically recorded. So there's a couple of things going on here. He's saying that Texas imposes these additional requirements to be able to interrogate him. He was interrogated in Texas, therefore these requirements should apply. So you can kind of already see where the substantive versus procedural distinction gets a little awkward because, you might think, well, if you're interrogating somebody in Texas and there's a procedure for how you're supposed to do that in Texas, shouldn't that apply to a Texas interrogation? And I think that would be kind of logical to reach that conclusion. But that's not what the distinction means, right? The distinction just means if it's procedural, then we apply the law where the case is being tried. So since the murder was in New York, we're applying New York standards to a interrogation that took place in Texas. So first he says these laws are all kind of in accord. They're all coextensive. But Miranda does not specifically say that you have the right to terminate the interrogation at any time. In Miranda, the right to terminate is required only as a subsequent procedure once the individual indicates a desire to remain silent or requests an attorney. So in other words, it follows from the exercise of some invocation of a right that you do have. But in and of itself, it doesn't just exist independently in the ether. This is the court's rationale about this. Even in this instance, although police interrogation must cease, express warnings are not required. Here, defendant had been given his Miranda warnings twice before making a statement. Each time he expressly waived those rights, indicating that he did not want an attorney. There is no suggestion defendant ever invoked his right to remain silent. Under both New York and federal constitutional standards, it is clear defendant was properly apprised of his Miranda rights. In our view, the people met their burden of establishing a voluntary waiver beyond a reasonable doubt. So under New York law, they're good to go. That's the issue. Under New York law, they're good to go. The question is, do we have to import these notification requirements and the recording requirements that Texas law imposed? So, in the alternative, defendant argues that even if New York law does not require the right to termination, Texas law does. He contends that failure to comply with the Texas statutes presents a substantive issue activating the law of the situs. This is the opposite of the forum. The situs is where the thing is taking place. So, if this imposes a limit on the manner of which in which interrogations can be conducted, defense is arguing you need to look at the law where the interrogation is conducted to determine if it's okay. So the trial court rejected this contention, finding that the issue was procedural in nature, necessitating application of the law of the forum state. In our view, it is unnecessary to characterize the issue as either substantive or procedural, since New York law should be applied in either event. Traditionally, procedural and evidentiary issues are governed by the law of the forum. This, once again, if you call a motion to suppress, it's an evidentiary issue. Are you going to use it in court or not? It's always going to fall under the law of the forum state. And so it's always, in Luigi's case, going to be New York law that applies. It is well established that the Miranda rule evolved solely as a procedural safeguard to protect the accused's privilege against compulsory self-incrimination. It has been held that admissibility of confessions presents a matter of state procedure. Beyond a strictly procedural approach, however, it is clear that this state's law governs, since New York has a paramount interest in the application of its laws to this case. The essential policy behind the exclusionary rule is to deter unlawful police activity, not redress a personal constitutional right of the party aggrieved. Here, New York police officers obtained a statement for use in a New York proceeding emanating from a violent crime in New York. Application of the exclusionary rule would not serve any useful purpose, since Texas authorities were not involved. Indeed, exclusion of the subject statement would serve to undermine the good faith efforts of the New York police in complying with the Miranda standards. The trial court, therefore, properly applied New York law in assessing the admissibility of defendant's statement. Premised on the foregoing, we find no error in the trial court's refusal to instruct the jury as to the provisions of the Texas statute. So in this case, we have a factual distinction that is notable. It might be really important, or it might not. We'll kind of see how it fleshes out in some of the other cases. But Benson is focusing very heavily on the reason why you have the exclusionary rule in the first place. And that's because if there's no consequence for violating people's constitutional rights, then the police will just violate their constitutional rights. And so the idea is that the exclusionary rule is supposed to deter them from doing that. So in this case, the fact that's kind of important here, I think, is the fact that it's a New York police officer that went to Texas to do the interrogation. And so that makes it kind of more important for New York to be evaluating the conduct of the New York police officer, because this is one of their own. And him doing things by the standards that he's accustomed to, by the standards that New York imposes, that's what New York is going to be the most interested in. Now, you can look at this easily the other way and be like, if your own cop is going to go to some other jurisdiction, shouldn't he be required to do it legally there? I mean, you might kind of make that point. Wouldn't you have just as much interest in preventing your police officers from violating the laws of another state as you would in making sure that they do things, according to the way that your state expects them to be done? Well, I mean, that's not the reasoning that they used in this particular case. But that is an important distinction, because that, of course, is not what happened in Luigi's case. They didn't have New York police officers go down right off the bat and start doing all of these searches and these interrogations and so forth. It was all Pennsylvania police officers that did this. There's maybe a little bit of a timing issue as far as when New York got involved, but the very least, the time Luigi is arrested, that initial investigation, the search of his backpack in the McDonald's, transporting him back to the jail, and at least the beginning parts of the search while he's in jail, all seem to have taken place before there is any like meaningful coordination between the Altoona Police Department officers and the NYPD. At least if we accept the testimony of the Lieutenant Tom Hanley of the APD, who was the one who reached out kind of from the outset to try to make contact with NYPD about their case, their investigation, let them know, hey, we're looking at this guy, might be the shooter. And ultimately made that contact, according to him, about 10:25 in the morning, which was about 9 minutes after police officer, patrolwoman Wasser had started the search of his backpack at the jail. So that was Benson, okay? And that describes, we've got these two different standards. Procedural is kind of always going to be, it's always going to be the forum state. It's always going to be New York law. So it's introducing us to this paramount interest test and saying, in this particular case, doesn't matter which one you do because they're both going to turn out the same. So now we have a different case here, People versus Graham. This is the other one that is cited in our canned brief here. And this involved, similar situation, kind of a crime spree, and, person moving across multiple state lines. And so as a result, there's activity going on in New Jersey, activity going on in Florida. And all of this is being sought to be used in relation to criminal charges in New York. So defense counsel argued strenuously that with respect to the New Jersey searches, the Florida warrantless arrest, search, seizure, and confessions or admissions, that New Jersey and Florida laws respectively apply. They maintained that under the laws of such states, the evidence obtained in said states should be suppressed pursuant to applicable law and or statutory law in said states respectively. The court is by no means convinced that New Jersey or Florida laws differ significantly in their application to the facts here from New York law. No expert testimony was offered, and they just basically cited the different legal provisions in the briefs. Thus, a threshold question must be determined, i.e., whether the laws of such states are to be applied with respect to the evidence sought to be suppressed, obtained in such states, or whether our own laws govern with respect to the admissibility of such evidence. Now notice, this is from 1977. Counsel have cited no cases bearing upon this conflict of laws question, and indeed this court has not been able to unearth any New York case law dealing with this conflict of laws problem in the criminal law arena. So this is kind of the issue of first impression at this point in New York. Back in 1977, for the very first time, we're looking at, in the criminal context, how do we decide these types of issues? Other jurisdictions, however, have looked at it. So we have first a Texas case where the defendant was a resident of Oklahoma. While he was in Texas custody, his wife at his Oklahoma residence permitted police officers to search their home in Oklahoma without a warrant. Contrary to Texas law, Oklahoma grants to each spouse a personal right to demand a search warrant for the search of the marital residence. Upon said search, which was made without the consent of the defendant, incriminating evidence was found and admitted at the Texas trial. The Texas court found the question to be evidentiary and procedural in nature, and thus governed by the law of the forum, and affirmed the conviction. Another case out of Illinois Faced with the same problem, the court adopted a broader approach, applying the significant relationship or center of gravity conflict of laws rule. The defendant in said case was convicted in Illinois of conspiracy to obstruct justice by concealing the body of a murdered victim on his farm in the state of Indiana. So now we have a situation transporting evidence across state lines. The victim had been murdered in Illinois, her body transported to and buried on the defendant's farm in Indiana. As a result of certain information obtained by the police as to where the body was buried, an Illinois police officer obtained a search warrant from a judge in Indiana, searched at the farm, and recovered the body of the victim. The affidavit upon which the search warrant was predicated was based upon hearsay information and conclusions of the police officer, clearly insufficient under Indiana law, although adequate under the law of the forum state, Illinois. The evidence was admitted at the Illinois trial. The Supreme Court, citing the Texas state and the Texas case and other authorities, upheld the conviction. The court pointed out that traditionally, conflicting principles prescribed that issues of clearly procedural nature are governed by the laws of the forum, whereas substantive matters are controlled by the laws of the state where the transaction occurred. Yet, with respect to conflicting state views concerning Fourth Amendment and other rights, the law has been changing and the older rules are being placed by more flexible rules, such as the rule significant relationship with each of the states in question. The court went on to say that if the problem presented was considered from the procedural substance viewpoint, that the evidence was properly admitted for two reasons, i.e., that evidentiary questions are generally governed by the law of the forum, and secondly, that if the conflict concerning the choice of law involves the preliminary issue of whether the evidence was wrongfully obtained, a substantive matter, then from the viewpoint of the significant relationship or center of gravity rule, the significant contacts in that state were with Illinois, in that the crime was committed there, was being prosecuted there, the defendant was a resident there, the great majority of witnesses were Illinois residents, that Indiana had no vital contact with the crime, and that the application of Illinois evidentiary law would not offend the comity of interstate relationships between Indiana and Illinois, and affirmed the conviction. Thus, we see that the Illinois Supreme Court applied the modern conflict of laws rules applicable to the civil area to the criminal case before it. So therefore, we also in New York can look at the civil cases. And the trend in our state has also been to apply the law of the state which has the strongest interest in the resolution of the particular issue presented. So a number of cases that they go through then in this civil context. Here's the one that I was thinking of with my example. He's a New York resident, owns an automobile, loaned to others for a trip to Florida. And then in North Carolina, there's an accident. And so, everybody gets sued. And basically, they decided that New York law was going to apply in that particular situation. In a New York case, New York civil litigation. Statute of frauds, arguably, that's one that's a little bit in the hinterland between substantive and procedural, right? If it's a statute of limitations, it tells you procedurally what your time frame is to be able to bring a cause of action against somebody. But it kind of affects your substantive rights to be able to pursue relief, because once the time limit has expired, you have lost your ability, your right to go and seek any type of recourse for that. So it doesn't really squarely fit within this procedural substantive type of analysis. So these are all the civil cases that they look at, where they basically come down on the side of applying this paramount interest test rather than the procedural versus substantive distinction. A third line of cases refers to the deterrent effect on police conduct if an illegal search in a different jurisdiction were suppressed. Of course, we all understand that searches, arrests, and confession made in violation of Fourth and Fifth and 14th Amendment rights are to be suppressed wherever made. However, a forum court can make its own determination of constitutionality subject to overriding federal case guidelines. Where evidence is illegally obtained in violation of local law, but not rising to constitutional proportions, the forum court can select the law to be applied and consider, in addition to the preceding approaches of Burge and Sakin, the deterrence approach. So now they look at this case, a criminal case out of California, where Indiana police are doing a search and they find evidence of a California crime. They give it to the California police. There's a prosecution that is initiated in California, and the court holding such evidence admissible under California law despite its illegality under Indiana law. The court applied the governmental interest approach. It also examined the deterrent approach, the reason for the exclusionary rule, and found that the police conduct in Indiana was not, quote, dirty business. It's an illegal search, but it's not dirty business, guys. It's totally fine. And that the police conduct was proper under California law. Notice in all of these cases so far that we've seen, it's been defendants that have been arguing to apply a law other than the state in which they're being prosecuted. And perhaps not surprisingly, if you look at court decisions as kind of incentive driven, and courts have the incentive to affirm outcomes, uphold convictions, and so forth, then you wouldn't perhaps be surprised that the law has evolved in this particular direction, because it's a product of the cases that were presented to it and the context of what it was being asked for. If you buy this kind of way of looking at how the law develops, then you might think that had the cases come up a little bit differently, where it was the state arguing that the law of the search, the place where it happened and not where the prosecution is taking place should be applied, we might have some different reasoning coming out of these cases, leading to different outcomes. But that's not what we have. It's not what we have. We have a series of cases where defendants have sought to apply out of state law, and the state where they are being prosecuted has said, no, we're applying our law. And, that's the case even when the reasoning doesn't necessarily seem to be all that clear. It's illegal in Indiana, but we can go ahead and use it in California. One of the things that happened during Luigi's motion to suppress that was so kind of attention getting to me was when the prosecution just backed off and withdrew certain statements that they had apparently. It wasn't exactly clear because we don't have the whole factual context, but it sounded like what happened is the prosecutor, Joel Siedemann, and one of the NYPD detectives, they show up in Altoona. They're going to interrogate Luigi. They set up a recording device, and then they leave the room. And it seems that apparently maybe Luigi says something to himself, while he's in this room. But the point here was that New York is a one-party consent state, so they don't, in New York, have to ask him for permission to be able to record the interview. Pennsylvania is a two-party consent state. They have to ask him for permission to be able to record the interview. And so by not doing that, they violated Pennsylvania law with how they conducted the interrogation. Orlovsky and Graham's reliance on Orlovsky seems to suggest that's kind of okay. That's fine. Because, the deterrent approach, was it dirty business? Did they know that Pennsylvania was a two-party consent state and decided not to do it? decided not to ask him for permission. Is there anything you really need to deter when they're doing things in accordance with the law that they're ordinarily subject to, and the law in the state where they're going to be seeking to use this as evidence? It's not real clear to me that was the case. Now, of course, there's the additional fact. There's always facts matter, right? And so the fact that the prosecuting attorney was involved might have been part of that issue there. But when that happened, my kind of immediate reaction to it was that this is really just the prosecution trying to be consistent with its argument that Pennsylvania law is what needs to apply to this search of Luigi's backpack. And so if Pennsylvania law applies to that, Pennsylvania law should apply to everything that happened to Pennsylvania. So therefore, we'll take the high ground, and apply Pennsylvania law to ourselves, acknowledge that we made a mistake, and withdraw these statements. That's just my take on it. I don't, know 100% sure that's the justification for it, but that's just kind of what it looks like. And it's ironic because, in fact, it kind of seems to be exactly the opposite. That by and large, no, it's New York law that's going to apply. And to the extent that there were additional requirements in Pennsylvania for how to record an interrogation, how to conduct an interrogation, those are procedural for the most part. But even if they aren't, you just look at the interests of the forum state, and hey, it's a prosecution that's happening there. It's a crime that happened there. It's New York officers that are acting. Seems like you got a pretty good argument that New York law would have applied to that decision to record the interrogation without telling Luigi about it. So they continue. Another case in California. So let's move on here. Let's get to the bottom line. Applying the foregoing principles to the case at bar, it is apparent that the state of New York has the greatest interest in this case, including the New Jersey searches, the Florida arrest, searches, and confessions or admissions. The alleged murder, kidnapping, and robbery occurred in New York State of a New York State citizen. The defendants were at least residents, if not domiciliary, of New York. Almost all witnesses in the New York prosecution are New York residents. They are focusing a lot on residency here, and that is a fact that we don't have in Luigi's case, because it appears that neither Luigi nor Brian Thompson are residents of New York. They were both, visiting, basically. But on the other hand, they weren't residents of Pennsylvania either. So not sure how or if that is necessarily going to weigh super heavily in the analysis, but it is a fact. It is a distinction, so it does matter. We'll point it out. The court will not say that neither New Jersey nor Florida have any interest in this case, as undoubtedly those states do have an interest in police conduct towards transients or visitors within their respective territories. But such interests are minor when compared to the overwhelming New York interests in prosecution of such heinous crimes as here committed amongst its own residents on its own soil. Indeed, the police activity in New Jersey and Florida was mainly conducted by New York State police officers with the assistance of police officers in said states and the use of facilities in said states in aid of the New York State police officers. So now again, we have a little bit of a distinction here where New York officers are going into these foreign jurisdictions and kind of doing things themselves. And that's a little bit different from what we have in Luigi's case, where you have the local police are kind of doing things on their own. Now they're doing it with a mind to what's going to be helpful to New York. And at least after a certain point, they're doing it after they have made contact with New York and they've had an opportunity to consult with them about their case, what would be helpful, what should we be doing procedure-wise, and so forth. So are these going to be definitive facts? No, they might be, they might not be. Further, the application of New York law in this instance would not offend the comity of this is, I think, supposed to be interstate relationship, the comity of interest relationship between New York and the other states involved, nor would the police conduct in New Jersey or Florida, if illegal, which this court does not find, require suppression as a deterrent. Accordingly, the court will apply New York law with respect to all of those transactions, subject only to overriding federal law dealing with safeguarding Fourth and Fifth Amendment rights of these defendants. So it denies the motions to suppress the evidence based on finding New York law applies to these searches and arrests in New Jersey and Florida. So on that, at least, we are squarely on point with what happened in Luigi's case. So let's go ahead and go back to our canned brief here, because we just read through People v. Benson and People versus Graham, and it was explaining this in the context of laying out this procedural versus substantive law distinction, but now also pointing out this framework has been criticized and largely abandoned in favor of this paramount interest test. And we kind of see that already happening in Benson and Graham, where they kind of acknowledge there's multiple ways to look at it. In Benson, they said, well, look at it either way, it's still going to come down to New York law. In Graham, they looked at it more. I mean, they did look at both, but they kind of looked at it a little bit more broadly through the lens of the paramount interest test. So now let's see what they have to say about this one. So New York courts have more frequently employed an interest analysis test, which is borrowed from the context of civil litigation, where a court must determine which jurisdiction has a greater interest in the matter. In fact, the predominant trend among New York courts is to apply the paramount interest analysis to any conflict of law issue. Benson again, and then some other cases. In determining whether New York has a predominant interest, New York courts have considered these factors. 1, where evidence is obtained outside of New York, but will be used to prosecute in New York, then New York has a paramount interest. 2, where the trial takes place in New York, then New York has a paramount interest. 3, where the crime occurred in New York, then New York will have a paramount interest. And 4, where the defendant and victim are both residents of New York, then New York has a paramount interest. So then they apply these standards to their case and say, under these factors, they all apply. And so New York law should have applied in his particular prosecution. We don't really care about his case, so that doesn't matter too much to me. But this law right here and these cases right here, okay, 4 factors, 3 of them apply to Luigi, right? Evidence was obtained in Pennsylvania, but it's going to be used to prosecute him in New York. So under that test, New York has a paramount interest. Trial is taking place in New York. That's where he's being prosecuted. We're not talking about Pennsylvania's ability to use this evidence to prosecute him in Pennsylvania for the fake ID and the, charges that they levied against him, the weapons charges and so forth. Where the crime occurred in New York, then New York will have a paramount interest. Yeah, this took place in Midtown Manhattan. So the only one we don't have where the defendant and victim are both residents of New York, then New York has a paramount interest. We don't have that, but they aren't residents of Pennsylvania either. So it doesn't particularly weigh in favor of using Pennsylvania law. And, I got to tell you, frankly, I'm not sure that that's really a huge factor anyway. Residency comes up a lot in the civil context because it matters for purposes of where can you actually prosecute somebody. If I get into a car accident in North Carolina, you might be able to sue me there. There are different kinds of statutes that states will have to like define, where the proper forum is for an action like that. But one place you can always sue somebody is where they live, and it just kind of creates questions like this about, well, what law do you apply in that type of situation? But if you sue me in North Carolina, you still kind of run into issues with how do you serve me? How do you do discovery with me? You have to go through interstate processes to do all these types of things. So it gets quite complicated, and that makes residency, I think, a little bit more significant in the civil context than it really is in criminal, because you don't distinguish really in any way in criminal cases, other than I suppose like bond decisions, whether somebody gets charged with a crime or not based on their residency status. Like it just doesn't factor in. Somebody doesn't become not a crime victim because they're not a resident. It's just not a thing. So I have to think that, like, of these factors, that fourth one is kind of going to be the least significant in all of them, and it's the only one that doesn't really apply in Luigi's case. So now let's go ahead, because we got more citations here, guys. Let's go ahead and look through some of these and see what they tell us. So the first one here, People versus Flores. This was a situation where guy is interrogated in New York. In New Jersey by New Jersey detectives. So this is getting a little bit more similar to the situation that we're dealing with in Luigi's case. The parties disagree about which forum's law applies to this statement. The defendant argues that New York law applies, while the people argue that New Jersey law applies. So before the court addresses a choice of law question, it must determine whether there is an actual conflict between the laws of the two states. Under New Jersey law, an individual who has invoked his or her right to counsel may thereafter waive that right outside the presence of counsel if he or she initiates further conversation with the police, and if the initiation of that conversation constitutes a knowing, intelligent, and voluntary waiver of his or her right. Under New York law, by contrast, once a suspect in custody invokes his or her right to counsel, he or she may not be questioned further in the absence of counsel. Period. So basically, New Jersey, they can change your mind. New York, you can't. Can't change your mind once you invoke. Because the application of New York and New Jersey law result in different conclusions, this court must decide which law applies. Now, again, take a look at our context here. So far, we've looked at cases where the defendant has argued the out of state law needs to apply, and the people have argued, nah, New York laws is what's appropriate. And the cases have gone along with the people so far and said, yeah, you know what? Here's all these reasons why New York law is going to apply under this situation. Now we have a role reversal. And we have a role reversal similar to what we have in Luigi's case. Now it's the people saying, we think we should use this out-of-state law and not New York law. Historically, courts' criminal cases look to whether the right at issue was procedural or substantive. If it was procedural, the forum's law applied. If the right was substantive, the citus's law applied. Our courts have held that rights related to a defendant's statements are procedural. Under this framework, given that the defendant seeks to suppress his statements, New York law would apply. Nonetheless, choice of law analysis based on whether a right is deemed procedural or substantive has been criticized on the ground that the distinction is often unclear, and as a result, courts have more recently employed an interest analysis borrowed from the context of civil litigation. Both parties in this case agree that that's the one that they should go with, so let's look at who has the greater interest. New Jersey's interests in the matter are as follows. New Jersey officers had custody of the defendant, having arrested him for crimes in their state. This is the same as Luigi's situation. Those crimes included burglary, a third-degree crime, carrying a sentence of 3 to 5 years, and trespass, a fourth-degree crime. The defendant now stands charged in New Jersey with those crimes and desecration of human remains. Further, New Jersey officers had established a crime scene at the vacant house in Ardsley Court in Teaneck, New Jersey, where they were continuing to investigate the possible secreting of human body parts and ultimately found such body parts. Uh, Factual background here is that this guy is found trespassing on the property of these New Jersey homeowners who show up. He's there. He's not supposed to be there. He gives them some excuses for why he's there. Says he has permission to be there. They're like, "Oh, we're the owners." No, you don't. So they call the police, and he starts kind of spontaneously telling the police that he had murdered his wife or his ex-girlfriend in the Bronx with some other person, and basically that he brought her here to New Jersey because he thought this would be a good place to be able to hide her. And so, describes kind of, how he did and what he did it. So the New Jersey police are, um, he's arrested for trespass and stuff like that. But they're interested in this case that he's telling them about, this potential murder that he's telling them about that took place in the Bronx in New York. So again, kind of a little bit of a similarity. We got independent crime under the out of state law, but there is law enforcement awareness of and interest in the crime that happened in New York. New Jersey detectives conducted the interview of the defendant without input from New York detectives in a New Jersey station house. So once again, kind of similar to at least the initial steps of the arrest and search of Luigi Mangione. This Pennsylvania officers doing it on their own, making their own kind of independent judgments about what to do and how to do it. New York's interests are as follows. First, it is the forum jurisdiction for this prosecution. Granted, if the forum jurisdiction always applied its own laws, there would be no need to engage in an interests analysis. Nonetheless, a forum jurisdiction does have a strong interest in seeing that its laws are applied. As a result, courts in criminal cases that have been confronted with a choice of law question frequently determine that their own law applies. The alleged murder, a Class A violent felony with a sentence range of from 15 years to life to 25 years to life, occurred in New York. Both the defendant and the victim resided in New York. New York has a particularly strong interest in applying its own laws in a case charging a defendant with committing a serious crime in New York that involves New York residents. Indeed, New York has the sole interest in the prosecution of this alleged murder. New Jersey has no interest in such prosecution. That is very much the same. Again, we got a distinction here with the lack of residency, but Pennsylvania isn't prosecuting Luigi for this murder that took place in New York. Only New York is doing that prosecution. Well, and the feds. That's going to be a different issue. The people argue, however, that at the time Detective Brzezowski interviewed the defendant, New Jersey detectives were investigating New Jersey crimes, so New Jersey's interests are paramount. The record demonstrates to the contrary, that the primary focus of the New Jersey detectives' interview was the alleged homicide, a New York crime, and their secondary focus was the alleged burglary and desecration of human remains, New Jersey crimes. Detective Brzezowski asked, for example, about the defendant's relationship with his ex-girlfriend, how the defendant killed his ex-girlfriend, what weapon he used, where the defendant was when he killed his ex-girlfriend and dismembered her body. New Jersey's secondary investigation into crimes other than the homicide cannot be a basis for applying New Jersey law in this New York homicide case. Well, now we got some similarity, don't we? Because the whole reason the Altoona police went out to that McDonald's in the first place was related to suspicions about the New York crime, the New York murder. That's what they were called out to investigate in the first place. Then we also heard over the course of the testimony about the search, particularly the search that took place at the jail, how they sorted out, they were kind of looking for things that they thought would be of evidentiary value for New York, and they sorted those out separately, and they detailed them separately, and they kind of maintained separate lists, and they prepared a search warrant to be able to hand those things over to New York. That stuff was not related to a forgery investigation. It was all related to their suspicion that this was the United Healthcare shooter, and they were trying to assist the New York investigators with being able to make the case against him. So that seems to be pretty similar here. Like, yeah, we have our own independent basis, but we're putting a lot of focus on this out-of-state crime. The people further argue that New Jersey's interests are paramount because the New Jersey detectives believed at the time of the interview that the murder could have happened in New Jersey. According to the people, New York did not have an interest in the matter until law enforcement confirmed that the alleged homicide occurred in New York. The court disagrees. New York's interest did not materialize only when there was confirmation that the alleged murder occurred in New York. Its interests are present even if the officers had been wholly unaware of the situs of the incident before Detective Brzozowski began his interview of the defendant. So basically saying in this, what police knew or what they thought isn't going to trump reality. The crime happened there. And so it doesn't really matter whether, they had discovered that or not, or what their thought process was in asking those questions about it. Murder of Brian Thompson happened in Midtown Manhattan. But even looking at the matter at the time of the inception of Detective Brzozowski's interview, the court cannot conclude that New Jersey's interests are paramount, as the people maintain. New Jersey law enforcement officers knew that there was a reasonable probability that the alleged homicide had occurred in New York, as the defendant himself had told Sergeant Balser that he had committed the homicide in the Bronx. That this might not have been communicated to the New York detectives is of no moment. Certainly, New Jersey law enforcement officers investigating the matter knew contemporaneously that there was likely a homicide and it likely had occurred in New York. It's exactly our situation in Pennsylvania. Moreover, although officers did not consider that there was no confirmation, there was certainly strong contemporaneous suspicion, simply no other explanation for the presence of all of these police officers at the station house in Teaneck, New Jersey during the interview of the defendant. Now this is really starting to come clear, isn't it? Why the cross-examination of so many of these witnesses went the way it did, and what exactly the defense was trying to elicit when they're pointing out there's like 15 officers in the McDonald's at one point in time. Every single person who was on patrol shift that day showed up at that McDonald's. That's because they all were interested in the New York shooting. They did not all show up that day because some guy gave a fake ID. That just does not pass the laugh test. So yeah, this was not independently motivated by Pennsylvania's own interest in Pennsylvania crimes. That's what the evidence from the hearing pretty clearly established. They didn't even really contest it. They really didn't even fight it. From the outset, this was all about the New York shooting and dispelling that suspicion or not. Although New Jersey detectives conducted the interview of the defendant without input from the New York detectives, they did so in the presence, in another room, of the New York officers who were kept apprised of developments. So I guess this is a little bit different. They were sitting actually there. Well, certainly by the time that this search of Luigi's backpack has gotten to the point of where they're laying things out on the table and they're photographing them and they are preparing search warrants and stuff like that. This is well after the first 15-minute phone call that Lieutenant Hanley has with a NYPD detective at 10:25 in the morning, because it was going on through, most of the day. So we're getting a little bit closer now to this type of situation. And Hanley testified that after 10:25, he wrote in his report, they were in contact pretty much continuously throughout the day. So maybe they're not physically present there in the room, but they're in reach by normal means of communication. There's consultation going on, there's back and forth happening, there's information being exchanged. Yeah, I would tend to think the New York detectives are kind of being kept up to speed on what's happening and what they found and so forth. Moreover, before they interviewed him, the detective from New York had opened a missing persons investigation. This led to him placing a be on the lookout for the defendant's van, registered in New York State, prepared to present a search warrant application for his residence. So the foreknowledge by the New York Police Department of the possibility that the victim may have been harmed, New Jersey's investigation of a New York crime, and the NYPD officers' involvement in the New Jersey investigation is what distinguishes this case from some cited by the people. The defendant's admissions about a homicide were not an unexpected byproduct of the interrogation by New Jersey detectives, which seems to be the case from this 2006 case out of the Bronx. To elicit such statements was the point of the interrogation. What most distinguishes this case from some cited by the people, however, is the enhanced importance of the right to counsel as recognized in New York jurisprudence. New York has a compelling interest in ensuring that the right to counsel is vigorously protected. As stated by our Court of Appeals, the safeguards guaranteed by this state's right to counsel clause are unique. By constitutional and statutory interpretation, we have established a protective body of law in this area, resting on concerns of due process, self-incrimination, and the right to counsel provisions of the state constitution, which is substantially greater than that recognized by other state jurisdictions and far more expansive than the federal counterpart. New York has some independent state constitutional jurisprudence. This is not uncommon. We've got this in my own state as well, where the Fourth Amendment provides the floor, but Washington has a lot stricter standards for when searches and seizures can be conducted, particularly without a warrant. And so because of that, we have some just different rules, that apply, different exceptions that are and are not recognized. So New York's got a higher constitutional standard. That's a pretty good reason for having a significant interest. If you're going to protect that interest, then you can't be allowing situations where it's exploited by an end run around it, right? By having essentially the Pennsylvania folks kind of take the laboring oar on developing the stuff, even though you're involved, you're in the background, they're doing it for your benefit in the first place. Then it kind of seems to apply. They need to go by your standards. Now, also implied is this would be a completely different situation if Pennsylvania was acting completely independently, no interest in a New York prosecution at all. They get called out for some other reason. Maybe the reason that they gave Luigi in McDonald's that they admitted was a lie. Maybe it wasn't a lie, right? Maybe McDonald's had called them and said, "This guy's been sitting here a long time. Can you come check him out?" And they say, "Okay." So they're going to investigate loitering, or something like that. And just in the course of completely independently investigating Pennsylvania crimes, arresting him, they happen to discover evidence that they later figure out is related to a New York crime. That might be a different factual situation, according to what Flores is telling us here. This case from the Bronx that they're relying on, where it was just an unexpected byproduct. They're doing their own things. They were not looking for it. They had no expectation they were going to find it. If that's what we were dealing with here, it might be a different situation, but it's not. It's not. We're dealing with a situation like Flores where they knew specifically we're interested in this out-of-state crime. And we're trying to help develop evidence related to this out-of-state crime. So, in this case, he invoked his right to counsel. New York has a paramount interest in ensuring that any statement that is elicited after such invocation, even if it's consistent with another jurisdiction's laws, is suppressed. Accordingly, the court concludes that New York interests are paramount and that New York law therefore applies. Because New York law prohibits the introduction of statements in the People's Direct case after the defendant has invoked his right to counsel, the defendant's motion to suppress his videotaped statement is granted. It's granted. Flores seems like a pretty good case for Luigi to me, because the only thing in it that really stands out as like this is markedly different is just the fact that Mr. Flores was a resident of New York and Luigi and Brian Thompson were not. But I'm just not sure that's going to be real definitive. If you commit a crime there, really doesn't matter. Really doesn't matter where you live. You're held to account wherever you can be found. So kind of an interesting scenario now that hey, police set up this standard, or prosecutors set up this standard where, hey, if defendants want to apply out-of-state law because out-of-state law has nuances that we're maybe not familiar with, we're going to persuade the court that they should apply New York law. But now when it comes to New York having heightened standards, heightened constitutional standards relative to other states, now we kind of want them to use that other state law. The court in Flores is saying principle has got to apply both ways. This is the standard you advocated for. So now you're going to get it. Govern yourselves accordingly. Just a quick look at some of these other cases that were cited in the brief. People versus Ostas. This was a case where a defendant is involved in a burglary that turns into a murder. She flees to Indiana and then is interrogated in Indiana. She is a minor at the time. And so Indiana has a law that says you can't waive your Miranda rights, basically, unless a parent does it or a parent is present, something along those lines. They did not do that in this case. And it was taken in Indiana by Indiana police officers, but it was to be used in a New York criminal proceeding generated by a violent crime committed in New York. Hence, New York has a paramount interest in applying its laws. So in this particular case, residency doesn't come in. It's a New York criminal proceeding. It's a violent crime in New York. That's enough for this court in Ostas to say, yep, we're going to apply New York law. We're going to allow it, even though Indiana police officers violated their own Indiana rules. Doesn't particularly matter. Yeah, here it is. By counsel, by the child's custodial parent, or by the child in the presence of one of those people. So yeah, Ostas, apply New York state law. Lerow. This was a case where a guy is he gets in a motorcycle accident. He is suspected of being driving under the influence, being a DUI. But he gets transported to another state for medical treatment. And so the police officer, the New York police officer, follows him into the other state, which happens to be Pennsylvania, and has them basically do a blood draw consistent with New York's implied consent law. And so we note at the outset the people are correct that New York law applies to the administration of the defendant's blood test because procedural and evidentiary issues are governed by the law of the forum. And New York has a paramount interest in the application of its laws to this case. So they go through what the requirements are of the implied consent law. Many states have them. Basically, when you get a license, you implicitly agree that you will give a breath test. And if you are unable to do that, they can take your blood to determine if you have alcohol in your blood system, as long as they have at least some reasonable suspicion to believe that. So they say he had probable cause based on the observations, 2 other deputies and an eyewitness. He was ejected. They smelled the odor of alcohol. And so there was probable cause to believe that he was DUI. And he complied with the requirements of the New York's law in as much as defendant's blood was drawn by a registered nurse at his direction based upon the requisite probable cause. And that so the issue that they litigated in this case was basically, did the New York police officer lose jurisdiction to be able to do this himself by crossing over the state lines into Pennsylvania? And ultimately, the court concluded that they did not. Apparently, this has come up in several states. Guess I shouldn't be that surprised. But where they get transported across state lines for medical treatment, because this type of evidence gathering activity by a law enforcement officer is not limited to the officer's territorial jurisdiction. So he remained a police officer for purposes of continuing his investigation. They also looked at exigency in this particular case because, alcohol will dissipate. You'll lose the evidence. It's important to be able to move quickly. And now, finally, People versus Johnson. We first turn to the defendant's contention that the county court erred in refusing to suppress his oral and written confessions because they were obtained in violation of the right to counsel that allegedly attached upon issuance of the Mississippi fugitive from justice warrant, because there was no probable cause for his arrest and because his arrest became illegal when these folks failed to comply with Alabama law. So here's what happened in this one. A guy commits a crime in New York. He flees to Mississippi and then flees to Alabama. Law enforcement in Mississippi are aware of the New York crime, so they prepare a fugitive warrant, which is basically like starting an extradition proceeding. They don't have their own independent crime that they're arresting him on, but they were under the mistaken belief that the New York prosecution had already been initiated, and in fact, it had not. There was no California or no New York prosecution that was ongoing at that point in time. So there's technically nothing to extradite him on. Nevertheless, they get this Mississippi extradition warrant. Guy flees into Alabama and they arrest him in Alabama on this Mississippi warrant. So, this gets all complicated, but bottom line, New York law, which we apply because procedural and evidentiary issues are governed by the law of the forum, the right to counsel attaches indelibly and therefore may not be waived in counsel's absence in 2 situations. First, when formal judicial proceedings begin, or when an uncharged individual has actually retained a lawyer or while in custody has requested a lawyer in that matter. And so in this particular case, they say he didn't have the right to counsel under New York law because he hadn't been charged yet in New York. And the Mississippi warrant doesn't charge a crime. It just presumes that a crime has been charged in another jurisdiction, but it's not in and of itself accusing you of doing anything wrong other than just being, in the state where there's another state that wants you for what they say is their crime. So they say, no, it's not significant judicial activity. It's not an accusatory instrument. But either way, his later waiver would still be okay. As far as their ability to arrest him in Alabama, these New York officers, they said, well, he was, they were if they're actively assisted by officers of the state where it's made, or if they do it as a citizen's arrest, if the state law allows that, then it's okay. And in this particular case, Alabama laws allow citizens arrest. So they said it's fine. Even if they weren't acting lawfully as law enforcement officers, they could do what they did as civilians. So this one, it was just real summary. Didn't even get into great depth about what we do, just New York law, which we apply because procedural and evidentiary issues are governed by the law of the forum. That's about it. That's as far as they're going to look at. So I hope that you guys are seeing by now how overwhelmingly this case law in New York seems to favor applying New York law to a New York prosecution. We have only seen one small hint at an exception to that, the case that was referenced out of the Bronx, where it appears that perhaps there was an incidental discovery of evidence relevant to a New York prosecution that occurred in an out-of-state investigation. But that's not the situation that we have here. We have Pennsylvania police who are initially called out in relation to suspicions involving a New York crime. They, conduct themselves in a way that is pretty consistent with them being primarily interested in the New York crime. They take actions in the course of the search to further and try to protect New York's interests by separating out things they thought might be of evidentiary value for New York, preparing a search warrant for those items for the New York police officers so that Pennsylvania would have authority to release all of that evidence to New York. Looking pretty strong to me, like New York law is going to apply to this situation. So, what does that mean? Well, it's going to be real significant when it comes to the search incident to arrest. The search incident to arrest justification for getting into Luigi's backpack. Two times when they asserted that this was the basis for what they did. First, when they were at McDonald's and did the initial going into his backpack, and then second, when they took it back to the jail. They said both basically a search incident to arrest and an inventory search. The inventory search is pretty much the same under New York and Pennsylvania law. There's no real distinction between the standards there. Both of them say that it cannot be a subterfuge for an evidentiary search. It needs to be conducted in accordance with some type of established policy. And the reason to do that is to eliminate police officer discretion in how they conduct the search. The whole purpose of an inventory search is to protect the department and the individual officers and so forth against claims that property has gone missing or has been broken or something like that. And similarly, to protect the rights of the defendant, the charged person, from having their stuff stolen or taken or lost or whatever. So we heard testimony at the hearing that sounds like it's probably going to undermine the inventory search claim. They have an inventory search procedure, a policy in Altoona. They talked about it at the hearing, but it's not part of the public exhibit, so we can't look at it very specifically. But the evidence did seem to indicate they didn't follow it. There were various details, like you're supposed to do this in the presence of the defendant so that everybody has their eyes on it, and then there's no misunderstanding about what we see, what's in there, where'd we put it, things like that. Everybody signs off on it. It's supposed to be done before the defendant is taken back into the cell. That plainly didn't happen in this case. But then you also have quite a bit of the testimony about how, they were looking for evidence to benefit New York, particularly once they found the magazine, which they found while they were in the McDonald's originally. Heightened their suspicion that they had the right guy, right? They're on video. It's him. It's fucking him. Separated it all out. Never really did a comprehensive inventory where you would just literally document all of the items. Just a list, an inventory of what you found. They had separate lists. They had his personal property, which is stuff that they originally were going to keep for Pennsylvania. And then they had the evidence that they, found that they were kind of segregating out for New York for their prosecution. And they ultimately ended up giving it all to New York, apparently, even the personal property. But there were kind of some notable things there as well, where, for example, Pennsylvania does have an evidentiary interest in the firearm and in the fake ID, the documentation that tends to establish that the New Jersey driver's license, Mark Rosario ID was fake. They have his passport, his real passport, his Maryland ID, and stuff like that. So those are all things that you would normally expect Pennsylvania to hold on to, because if they're going to prosecute him for Pennsylvania crimes, they need that evidence. But they didn't do that. They handed all that over to New York as well. They did things like photograph every single page of the Red Journal. Every single page. They photo documented. Now, this is just not the type of thing you normally would need to do for an inventory, because what's on the pages doesn't matter. You just document that it's a Red Journal. If it's got pages torn out, you might document it's got some pages torn out. You document the condition of it. But what it says is not remotely relevant to whether somebody is potentially going to be on the hook for damaging it or losing it or something like that. So there was a lot of evidence about the inventory search justification that really seems to kind of call it into question. And so they fell back heavily to relying on this case. They called this case out by name a couple of times. Guzman. Let me blow it up for you guys to make sure that you can read it. Guzman is a case out of Pennsylvania that establishes the search incident to arrest exception in Pennsylvania. And so this is a drug bust, and they have a confidential informant, sets up a buy, and the defendant ends up, showing up to do it. He's got a bag. It's big enough to contain the amount of drugs that they're looking for. So they seize him and search the bag, and they find, it's probably cocaine. And at the end of the day, get back to the police station. 2 packages were opened without a search warrant, and they yielded more than 2 kilos of cocaine. So they don't have a warrant for any of this. First, they say the arrest is no good, but this is not particularly pertinent to our point. The second contention is that the warrantless search of his satchel was illegal, and therefore the cocaine should have been suppressed. The Fourth Amendment and Article 1, Section 8 of the Commonwealth's Constitution bars unreasonable searches and seizures. However, it is, of course, axiomatic that an arresting officer may, without a warrant, search a person validly arrested. And the constitutionality of a search incident to a valid arrest does not depend on whether there is any indication that the person arrested possesses weapons or evidence, as the fact of a lawful arrest standing alone authorizes a search. So this is the Pennsylvania standard, how they apply it. They find that the warrantless search of his bag was proper as a search incident to a lawful arrest. So here is a similar case, a guy that is arrested without a warrant for possession of marijuana. He was carrying a bag on his shoulder. The officer who arrested him took the bag, opened it, discovered a bunch of marijuana. They cited it was a search incident to a lawful arrest. Instantly, they seized his satchel from his person at the time of his arrest, opened the bag, and discovered inside 2 packages consistent with those in which kilos of cocaine are shipped. We find the search of the appellant's bag was proper in order to determine whether there were any weapons present and further to prevent the destruction of any evidence. Now, notice how they had just said, it doesn't matter. It doesn't depend on that. Those things don't matter. Nevertheless, in this particular case, they still did it just to be sure he doesn't have any weapons or isn't going to be able to destroy 2 kilos of cocaine. I'm not quite sure how that's going to happen, but so this is kind of equivalent to what we're dealing with in the McDonald's search, right? The one that happened right at the point of arrest. The big factual difference here, this guy, he's got his bag on his shoulder. Luigi, it's at his feet. May or may not be dispositive in Pennsylvania. They don't really get into that particular distinction in this case, but it is a factual distinction and one that's important. By the time that Luigi was arrested, they had moved that bag, put it on the table, across the little walkway from him. A whole bunch of police officers standing in between him and them. He's handcuffed, etc. All potential differences in the facts. But now we're getting to the jail. Appellant objects not only to the initial search, but also to the continued search at the police barracks of the 2 packages discovered inside the satchel. So they arrest him, they take him to jail, and then they keep searching him and say it's all search incident to arrest. Appellant argues that since the police had exclusive control of the satchel subsequent to his arrest, they were required to obtain a search warrant before unwrapping the packages. The record reveals that within 1 hour after returning to the barracks, the police unwrapped the opaque packages, thus revealing the cocaine inside. The United States Supreme Court held that once an accused has been lawfully arrested and is in custody, anything that was subject to search and seizure at the time and place of arrest may be lawfully searched without a warrant, even after a substantial amount of time has lapsed following the arrest. Therefore, we find that no impropriety in the officer's actions, since the packages could have been legally opened at the time of the appellant's arrest. So under Pennsylvania law, if you don't search it at the scene, that's okay. That's okay, as long as you could have dug through the entire backpack at the scene, justified as a search incident to arrest, then it's totally fine that you went back to the police station and did it later. New York law is real different, guys. New York law is real different. That's why this is going to be such a critical issue. And that's why the state wants so much for this Guzman case to be the one that applies. But I'm not so sure that it is. Let's take a look at 2 cases that the defense cited in their memorandum. First, we have Gokey. Gokey says a duffel bag that is within the immediate control or grabbable area of a suspect at the time of his arrest may not be subject to a warrantless search incident to arrest unless the circumstances leading to the arrest support a reasonable belief that the suspect may gain possession of a weapon or be able to destroy evidence located in the bag. There being no such exigency present at the time the police searched defendant's bag here, the motion to suppress should have been granted. Right off the bat, we see there's a distinction between this case and Guzman, because Guzman said, we don't care. It doesn't matter. You don't have to have actual facts supporting any reason to think that there's a weapon here or that there's going to be evidence destroyed or something like that. That's not what we require legally. New York says, yeah, but we do. We require that. There has to be an exigency. So this is a case, a tip, another drug case. guy's got marijuana. So they meet him at the bus station with an unrelated warrant for his arrest. They bring a drug dog with them. He's got a bag. He's ordered to place his hands against the wall so he could be frisked. The duffel bag lay on the ground between the defendant's feet. The dog alerted to the bag, and then he's handcuffed, and then they search the bag and find approximately 11 ounces of marijuana. So he moves to suppress. So in New York versus Belton, the Supreme Court set forth a general rule under the Fourth Amendment that a custodial arrest will always provide sufficient justification for police to search any container within the immediate control of the arrestee. Under this standard, it is clear that the defendant's federal constitutional rights were not violated. This court has declined to interpret the state constitutional protection against unreasonable searches and seizures so narrowly. Look here, we're citing New York Constitution, Article 1, Section 12. Under the state constitution, an individual's right of privacy in his or her effects dictates that a warrantless search incident to arrest be deemed unreasonable unless justified by the presence of exigent circumstances. When an individual subjected to arrest has a privacy interest in property within his or her immediate control or grabbable area, this court has identified two interests that may justify the warrantless search of that property incident to a lawful arrest: the safety of the public and the arresting officer, and the protection of evidence from destruction or concealment. The reasonableness of a police officer's assertion of the presence of either or both of these predicates to justify a warrantless search is measured at the time of arrest. Moreover, the search must have been conducted contemporaneously with the arrest. Pennsylvania says you can just wait and do it later. New York says no. No, you cannot. In People v. Smith, for example, this court upheld a search by police of an arrestee's briefcase that was within the arrestee's possession at the time of the arrest as a reasonable search incident to arrest. Determinative of the search's validity were the facts that police reasonably believed the defendant was in possession of a weapon, as was evidenced by his wearing a bulletproof vest. The briefcase was large enough to contain a weapon. It was not so securely fastened that the defendant would not have been able to gain access to it. The officer's reasonable fear for their safety was found not to have dissipated merely because the defendant was moved off a subway platform into a porter's room less than 10 feet away before the search was initiated. The search of the briefcase was conducted virtually contemporaneously with the arrest and immobilization by handcuffing of the defendant. Now, this sounds quite a lot like what happened in the McDonald's. They had him separated. They had him handcuffed. In this case, it was less than 10 feet away. It's very similar distance that we're dealing with in that McDonald's. But they had the facts. Police reasonably believed that he was in possession of the weapon based on these specific facts. What do they have here? Well, they just knew that the New York shooting involved a shooting. And so possible, if this is him, he's got a gun, I guess. A bomb. Bombs seem to be pretty remote. That was based more on Pennsylvania has had bad experiences with bombs in backpacks before. And so they seem to just kind of generically assume that maybe there is a bomb in the backpack. But that's not an individualized type of suspicion. That's normally, what you need to justify this kind of a search. So based on this, seems a little bit more likely that the search inside the McDonald's is going to be okay versus what happened after there was a substantial delay. Now here is Johnson. A warrantless search of a handbag located approximately 2 feet from the defendant at the time of his arrest was upheld because police reasonably believed at the time of the search that the defendant might gain access to the weapon. They had received a radio call about a man with a gun, were instructed to investigate. Building and superintendent warned them that a man had just struck him over the head with an automatic pistol. Police entered the apartment and contemporaneously with the defendant's arrest dumped out the contents of the bag, which was in easy reach of the defendant who had not yet been handcuffed. Perhaps we have, similarities again here. I think the main distinction between this kind of fact where they have a report, man with a gun, we think this is the guy versus shooter in New York and we think this is the guy, is the staleness of the information. This is still, in Johnson, very fresh information. In the shooting of Brian Thompson, it's been several days that have gone by. And so, a lot of opportunity to be able to get rid of a weapon or something like that. So it's a fact that might distinguish what we have to work with in Luigi Mangione's case. But by and large, looks a lot of a closer call anyway, that New York, as long as they can establish some kind of exigent circumstances, that's going to be okay. The problem, though, is that delay. The delay. In the present appeal, the people have not asserted the presence of any exigency to justify the warrantless search of the defendant's duffel bag. They sought his arrest for 2 nonviolent crimes. People concede that, in all frankness, there was no immediate suspicion by the police officers that the defendant was, in fact, armed. This might be getting at some of the cross-examination that came out during the testimony about, like, you guys weren't even really worried. You can say kind of ostensibly, oh, it was for safety considerations, but you didn't act in a way that suggested you had those type of safety considerations or really took them seriously. They all testified the scene was under control. They're allowing people to come and go. Not real worried about it. They're not clearing the area. They're not calling in the bomb squad. If we're legitimately, thinking there might be a bomb in this bag. Had the opportunity to, be more protective of the bag, I guess, than they were, because of the amount of time that elapsed from when they first contacted him in the McDonald's and when they finally get into the bag. They were in control of the distance and the proximity the whole time. So all these things might be going to this same kind of concession. Yeah, they didn't really suspect he had anything. Yeah, honestly, we didn't really think he was dangerous. Just didn't really. Could be. Well, we'll have to see. Furthermore, police have not asserted, nor on the facts of this case, could they reasonably rely on a belief that the search was justified by the need to preserve evidence located in the bag. Again, the presence of any exigency is belied by the police officer's failure to seize the bag immediately upon encountering the defendant. That seems pretty similar. I mean, the bag sat there for 10 minutes before anybody shoved it with their foot. And then, longer before they moved it up on the table. They were with him for like half an hour before they got into this bag. By the time the search was undertaken, defendant's hands were handcuffed behind his back. He was surrounded by 5 police officers and their dog. Therefore, because the police conceitedly did not fear for their safety, and because they could not have reason to believe that the search of the bag was necessary to preserve any evidence that might have been located in it, the warrantless search of the bag was invalid. Gokey isn't looking real good for the people in this case. Not looking real good for the people in this case. The delay, I think, is going to be significant, because that's really where there is a substantial difference between the Pennsylvania standard in Guzman that says we don't care if a bunch of time has elapsed as long as you were able to get into it in the first place. And New York law requires that it be contemporaneous with the arrest, at the time of the arrest, not after the exigency has been dissipated, because you've already taken the guy to jail and he's locked up in a cell behind, multiple doors of locking steel. No ability to get to it at all. There's no more exigency at this point. So that, guys, that is the kind of legal in-depth reason here why I think this motion has a lot better chance in New York, definitely than I thought when I first looked at it. First kind of got the idea of what was involved. It's a little bizarre to me because I guess I didn't expect the evidentiary hearing to unfold this way. I really didn't. I mean, most of the time, what happens in an evidentiary hearing on a motion to suppress is that the police come in and they figure out how to fill in the holes of what their report contained. You know, they've already kind of rationalized through how to excuse the weaknesses and stuff like that, and it just that really didn't seem to happen in this case. They leaned all in on this was fine to do it under Pennsylvania law. We did everything in accord with Pennsylvania law. And had there been no suspicion of the New York shooting at all in any of this, then maybe that would be okay. But it seems pretty clear under Flores, those other cases, if you're going to use this in a New York court, relating to a New York crime, and even if it's not your own New York state officers, if it's out-of-state officers doing it with an interest in your New York state prosecution, they got to follow your New York state standards, or New York's not going to allow it. So if they can get it justified as an inventory search, I think they're still good to go. But I think they're on an uphill battle with that, given their massive deviation from their own policies and their kind of frank acknowledgement that a lot of what they were doing here was looking for stuff that had evidentiary value, not to them, but to New York. If they have to justify this as a search incident to arrest, then I think the state law determination, the choice of law determination, is going to be absolutely dispositive, because the fact that Guzman says it's okay in Pennsylvania doesn't mean that that's the standard that's going to be applied in New York. And the case law seems to all fall down pretty hard on the side of the law of the forum applies. You have a real good reason to look outside it. So that means New York. That means we're using that Gokey standard. That Gokey standard doesn't look real good for the people in this case. So I hope you've enjoyed this little exploration through what it is that lawyers do when they're looking at an issue like this. The nice thing about the law is that you don't have to take anybody's word for it. The law is not an idea that exists in somebody's head. It's something that is written down on paper. And so you can always find it. Now, how it applies to any particular set of facts might be what you argue about in any given case. But finding the standards and thinking about, how are they the same as my case? How are they different from my case? What does that tell me about how this law is going to ultimately determine the outcome in my case? That's just classic legal research and analysis. It's the type of thing that we do every day. So hopefully it wasn't too dry, but I did just want to share that with you so that you could see why I've been yelling and shouting and waving my hands in the air. I don't think Pennsylvania law is going to apply here. And it's not just because I don't think so. It's because this is the law written down, adopted formally in the state of New York. This is what it says about it. And based on that, why I think people are really on the back foot here. And I think there's a very decent chance that they are not going to win that argument, and this motion to suppress is going to be granted. So we have some stuff coming up. They did announce some deadlines at the end of the final day of the hearing. We are getting supplemental briefing. I fully expect we're going to see a lot of these cases again, and this choice of law distinction again in some of this briefing. So the defense is going to be filing their brief on January the 29th. The state will file their brief in response on March the 5th. And then the court has set aside May 18th for its ruling. So 2.5 months after the briefing is complete, we're going to get a ruling. This might seem, fairly, I think, as kind of an unreasonable delay, very, very lengthy time period to sort out this issue. In the meantime, the accused is still presumed innocent, is being held in custody. How is that fair, and so forth? And plenty of good arguments to be made about the speediness of the trial and so forth. But I will say that in this particular case, I think that this length of time is actually beneficial to the defense. Because if nothing else, it's clearly signaling that the judge does not consider this to be a pro forma easy decision. And suppression rulings often are. When you file your initial motion based on what you read in the police report, and then you have the evidentiary hearing and the police officers come in and then they add to that report to fill in the gaps of the things that seem to have created a problem when you filed your brief. Well, now you don't really have facts to rely on to support your argument. It makes it very easy for the court to rule on. Doesn't take a whole lot of time to do that. So it's really only when there's at least potential merit to what you're arguing that you need this kind of extensive time to be able to get it done. Now you might say, well, yeah, it was a long hearing. There's a lot of transcripts, a lot of evidence to go through and keep track of. But the thing is that that's all available right now. There's nothing stopping the court from going ahead and getting started on what the evidence established at the hearing. So it's really this time that the court wants to spend with the briefs that I think is the real tell here. That he doesn't think this is just a foregone conclusion, a real easy snap decision that he just needs to kind of verify his gut reaction. It sounds like he thinks he needs to take this pretty seriously. So I'm going to be keeping my eyes out for those briefs. Very excited to see that. Intrigued to see how it comes out. Perhaps we will be seeing some of these cases again. So keep your eyes open. Flores is the one I'll be looking for from the defense. No question about that. So guys, appreciate you joining me for this little adventure through the case law on this issue in New York. And hope that gives you a little bit of a better understanding of where I sit on Luigi Mangione's motion to suppress, why I think it's got such a good possibility of a favorable outcome for him. So it remains to be seen. I will keep my eyes open. I will follow up when we have more information. And guys, in the meantime, have yourselves a very happy new year, and I will see you next time.